In an era where every click, swipe, and scroll generates a data trail, the value of personal information is on a rapid rise. Each online interaction gives away fragments of who we are, preferences, identities, behaviors, slowly constructing a detailed digital profile. Creating a legal framework for privacy protection has become the need of the hour, with countries, including the EU, in a rush to create a framework while ensuring digital progress. Responding to this challenge, India enacted the landmark Digital Personal Data Protection Act 2023, India's first comprehensive data privacy law, aiming to protect citizens' personal data. The Act draws strength from the historic Puttaswamy judgment of 2017, which recognized privacy as a fundamental right.
पुट्टुस्वामी की जजमेंट ये कहती है कि जो फंडामेंटल राइट्स हैं वो राइट ऑफ प्रिवेसी भी उसी का एक पार्ट है. तो जैसे राइट टू लाइफ हो गई, राइट टू प्रिवेसी भी एक इंटीग्रल पार्ट हो गया. इसका मतलब ये हो गया कि आपकी जो इंफॉर्मेशन है उस पे आपका मौलिक, आपका कंप्लीट अधिकार है और कोई भी व्यक्ति आपकी इजाज़त के बिना, बिना आपके कंसेंट के उस इंफॉर्मेशन को ना ले सकता है, ना यूज़ कर सकता है और ना ही मिसयूज़ कर सकता है.
Anchored in the principles of data sovereignty, transparency, and individual autonomy, the DPDP Act marks a transformative step in securing India's digital future, one where privacy is no longer a privilege but a guaranteed right. To ensure its effective rollout, the Ministry of Electronics and Information Technology notified key provisions of the Act on November 11, 2023, laying the groundwork for its phased implementation. Simultaneously, steps are underway to operationalize the Data Protection Board of India, which will serve as the enforcement and adjudicatory body under the Act. These actions reflect the government's intent to establish a robust digital regulatory ecosystem by mid-2025, ensuring compliance readiness while allowing time for institutional capacity building.
The Data Protection Board of India is going to be a statutory board because it's a creature of the DPDP Act. That being so, it's not under the government. But yes, the government will have the power to nominate its members. It's supposed to act as an independent body. It is supposed to be going ahead and supervising the data ecosystem in the country. More significantly, it will be the legal entity that will help determine what quantum of fines need to be appropriately awarded. So whether you're going to be awarding a 50 crore rupee fine or a 250 crore rupee fine, that particular decision has to be left on the Data Protection Board.
What is personal data? The Act defines personal data as any data that can identify an individual. This includes names, phone numbers, addresses, biometric data, location history, and even online behavior. It is important to note that this particular Act concerns itself only with the information that is available digitally and not otherwise. Who and what does the law cover? The Act sets out a wide and forward-looking scope in terms of its applicability, establishing a comprehensive jurisdictional reach that governs not just Indian companies and residents, but also extends its influence beyond national borders. This includes coverage of digital personal data, applicable to all digital personal data regardless of whether the data was collected directly in digital form, such as through websites, apps, or online forms, or collected offline by subsequently digitized, such as physical forms or documents that are later uploaded to a database or digital system. This provision ensures that no loophole exists through which offline collected data, once digitized, can escape the purview of the law, whether it's a hospital scanning handwritten medical records or a bank entering physical application forms into a CRM system. All such data now falls within the ambit of the Act. Jurisdiction within India. The DPDP Act covers any processing of digital personal data that occurs within the territory of India, whether done by private companies, startup and tech platforms, state or central government departments, statutory body, or government undertakings. This makes the law applicable to all sectors, from healthcare and education to e-commerce and insurance, fintech and government services, wherever digital personal data is being handled. Extraterritorial jurisdiction. In an increasingly global digital economy, the DPDP Act also asserts its jurisdiction outside India. That is, it applies to any data processing activity that relates to the offering of goods or services to individuals located in India. This means a foreign e-commerce platform shipping products to Indian consumers, a global streaming service targeting Indian users with Indian content or currency pricing, a foreign edtech company offering courses to Indian students. All of these are bound by the DPDP Act, even if they do not have a physical presence in India. This clause mirrors global standards like the EU's GDPR, which also applies extraterritorially. It reflects India's growing assertiveness in digital governance and its intent to protect Indian users' data globally wherever it may travel. Non-citizens residing in India. Another key feature of the DPDP Act is that it applies to both Indian citizens and non-citizens residing in India. This includes recognizing the data rights of expats, foreign students, diplomats, tourists, and refugees while they are within India, emphasizing the residency, not citizenship, is the basis for protection under this law, which in turn reinforces India's commitment to universal data protection within its territory. This makes the DPDP Act one of the more inclusive and rights-focused privacy legislations globally, as many other countries' law focus narrowly on their citizens alone.
For the first time, the DPDP Act has made the data principle the center point of the data ecosystem and universe. Prior to this law, nobody was asking about us for our data, for our permission. They were in any case using our data. But now, under this law, nobody can use a data principal's data till such time he or she gives a notice in writing to the data principal asking them that, look, we want to collect your data and we want to collect it for these particular purposes. Please give us your consent and permission. So for big companies, they will have to put in not just a data protection officer, but they'll have to make sure that they will have to give the option to the data principal that the data principal may at any point of time withdraw his consent. Now that means they will have to do it as expeditiously as possible. They'll have to have appropriate mechanisms, processes and procedures which can enable people to exercise the right to erasure. And in case if the company does not erase the data, then they are playing with fire, because then a complaint can be raised against them and they can be fined up to 50 to 150 crore rupees under the DPDP Act.
Key principles, the backbone of the law. The DPDP Act is built on 7 foundational principles. Lawful and transparent use. Data must be used only after obtaining clear and informed consent. Purpose limitation. Data can only be used for the specific purpose it was collected for. Data minimization. Only the necessary amount of data should be collected. Data accuracy. Data must be correct and regularly updated. Storage limitation. Data must not be kept longer than necessary. Security safeguards. Reasonable measures must be taken to protect data from breaches. Accountability. Entities handling data must be held responsible for misuse or negligence. Consent is central to the DPDP Act, with clear requirements that personal data can only be processed after receiving explicit, informed, and voluntary consent from individuals. Importantly, individuals can draw their consent at any time with a simple and transparent process. However, there are exceptions. Data can be processed without consent in situations related to public welfare, government services, or national security, ensuring that the Act does not impede essential government functions. The exceptions allow processing of data without consent under legitimate uses, which include when individuals voluntarily share their data, when the state provides services like subsidies, licenses, or certificates, for law enforcement, national security, emergencies, epidemics, or court orders. This dual framework of consent and legitimate use aims to balance the individual right with effective governance. Who are the stakeholders? The Digital Personal Data Protection Act outlines a right-based framework, and at the heart of this framework are the three primary stakeholders, each with distinct roles, responsibilities, and legal implications. Data principles. The term data principal refers to the individual to whom the personal data belongs to. In simple terms, it's you and me. Any person whose data is being collected, stored, shared, or used. Rights of data principals include the right to access their personal data, the right to correct or update inaccurate or incomplete data, the right to erase data when it's no longer necessary, the right to consent or withdraw consent for data processing, the right to grievance redressal through the data fiduciary or the data protection board. This category empowers individuals as active participants in the digital ecosystem, rather than passive data sources. The law positions them at the core of data protection. Next on the list is a data fiduciary. It is an entity, public or private, governmental or commercial, that determines the purpose and the means of processing personal data. This include tech companies, bank and financial institutions, e-commerce platforms, government departments collecting citizen data, hospitals and schools handling digital records. The duties and responsibilities are to ensure lawful and transparent processing of data, maintain data accuracy and security, obtain valid consent from data principals, facilitate compliance with individual rights, report data breaches to the Data Protection Board and affected users. Its obligations on data fiduciaries require them to ensure accuracy and completeness of data, use secure systems to avoid data breaches, notify the affected individuals and the Data Protection Board in case of breaches, delete data after the intended purpose is complete or if consent is withdrawn, set up accessible grievance redress mechanisms. For processing data of children under 18 years, parental consent is mandatory, targeted advertising and behavioral monitoring are banned. Data fiduciaries are the executors of data processing and hold accountability under the law. Their actions directly affect the trust and safety of data principals.
जैसे कि कभी मिसयूज हो जाए तो जो सबसे पहली चीज़ होती है वो ये होती है कि आप जो फिड्यूशरी है, जो कंपनी है, आप सबसे पहले तो उस कंपनी में आप कंप्लेंट करेंगे। कंप्लेंट आप जैसे ही करेंगे, अगर उसका वो रिजात नहीं करते हैं तो आप उसको फिर एस्केलेट करेंगे। अब इसमें भी दो चीज़ें होती हैं। एक ये होता है जो कंपनी है उसको 7 दिन के अंदर इसको रिजॉल्व करना ज़रूरी होता है। कुछ स्टेजेस में रिस्पॉन्ड टाइम 30 दिन से ज़्यादा नहीं हो सकता। अगर वो उस पीरियड के अंदर नहीं करते हैं तो आप उसको एस्केलेट करते हैं और आप इसको एक बोर्ड पे ले जा सकते हैं।
Significant data fiduciaries. Among data fiduciaries, the Act introduces a special category called significant data fiduciaries, those that process large volumes of sensitive personal data or handle data that poses higher risks to individual or to national interest. The central government designates an entity as an SDF based on factors such as the volume and sensitivity of personal data processed, potential impact on sovereignty and integrity of India, risks to electoral democracy, security of the state or public order, technological complexity, and scale of data processing. Additional obligations of SDF include appointing a data protection officer based in India, conducting periodic data protection impact assessments, implementing robust data security practices, maintaining audits and compliance records. This classification ensures stricter scrutiny and greater accountability for larger players, especially tech giants and government agencies with sweeping access to personal data. It is a context-sensitive model to data governance. However, one must remember the DPDP Act is not a one-size-fits-all framework. By distinguishing between data principals, fiduciaries, and significant fiduciaries, it creates a layered responsibility structure. This ensures that individuals are protected, entities are regulated proportionately, the government retains control over national security concerns. This ensures higher standard of privacy for entities operating at large scale or handling sensitive information.
Digital Personal Data Protection Act has basically sought to identify three broad players in the data ecosystem. Data principal, that's people like you and me to whom data belongs. There is data fiduciary, who determines how my data has to be collected and processed. And third is a data processor, who actually goes ahead and processes data. Now, in the category of data fiduciary, the law has basically come up with two subcategories. One is a normal data fiduciary and one is a significant data fiduciary. Now, how will you become a significant data fiduciary? The government will notify by the rules under the DPDP Act as to what will be the minimum threshold, the crossing of which will enable you to become a significant data fiduciary.
Data Protection Board of India. The Data Protection Board of India, or DPDPA, is central to the enforcement of the DPDP Act. Its powers include investigating data breaches and complaints, imposing financial penalties, recommending blocking of repeat offender app or website, facilitating disputes resolution and accepting voluntary settlements. Financial penalties for non-compliance. The DPDP Act imposes stringent penalties for violation. These fines can reach up to 250 crore rupees for failing to protect personal data and up to 200 crore rupees for not reporting data breaches within the stipulated time. The scale of these penalties highlights the government's commitment to enforcing data protection laws and holding entities accountable for breaches. Data localization and cross-border transfers. The Act allows for the free flow of data across borders with certain restrictions to protect national security and public welfare. While it mandates data localization for sectors such as finance, it offers flexibility for international data transfers, balancing the need for protection with global movement.
Everybody in India has to comply with the DPDP Act. Why? It will apply to any person who's collecting, storing or processing personal data. So if you are a small entity, if you're a big entity, you're a government entity, you're a non-entity, no problem. The law wants every one of you to ensure compliance. Yes, the government has been given the power to exempt certain agencies from the applicability of the DPDP Act. So if you're going to be exempt by the government as a category, you will not be required to ensure compliance with the DPDP Act, but here is a proviso. Under the second schedule of the draft Digital Personal Data Protection Rules 2025, there are now set of minimum requirements of cyber security. Now, independent of whether you are exempt or you are non-exempt under the DPDP Act, you will still have to ensure compliance with those cyber security norms and standards. Basically, you will have to put in reasonable security safeguards whenever you are dealing, handling, or processing sensitive personal data or personal data. So, I think the misconception that this law is only for private sector is really a misconception. It's a myth. It's for everyone. And you better well comply. You don't comply, and be prepared to face one of the most horrendous fines that you can think in your life. You can actually be fined up to 250 crore rupees for one contravention under the DPDP Act if you choose not to comply with the same.
Innovative features of the Act. The Digital Personal Data Protection Act of 2023 introduces several groundbreaking features, setting it apart from existing data protection laws globally. Plain language. The Act is written in clear, accessible Hindi and English, making it easy for citizens to understand it. This emphasis on plain language ensures that legal terminology does not alienate the average person, promotes greater transparency and public trust. No provisos. Legal clauses are structured in a straightforward manner, avoiding complex legal clauses. This clarity in drafting helps in better interpretation and understanding, reducing ambiguity and potential for misapplication of the law. Gender inclusive drafting. For the first time in India's legislative history, the Act adopts gender inclusive language by using she as the default pronoun. This progressive approach ensures that the law reflects equality and inclusivity, setting a precedent for future legislation. Digital nominee. The Act introduces the concept of a digital nominee, allowing individuals to appoint someone to manage their personal data after their death or in case of incapacity. This provision ensures that data rights are respected and properly managed beyond an individual's lifetime. Benefits of the law. The DPDP Act offers significant benefits, such as empowering citizens. The Act provides individuals with greater control over their personal information, allowing them to make informed decisions about data sharing and usage. Increased transparency. The Act enhances transparency, ensuring that individuals are well informed about how their data is collected, processed, and stored. Builds trust in digital platforms. By establishing clear data protection standards, the Act boosts trust in digital platforms and services, fostering wider adoption of digital solutions. Promotes ease of doing business. The Act creates a unified legal framework that simplifies regulatory processes, ultimately enhancing the ease of doing business in India. Supports Digital India and startups. By offering clarity and reducing compliance burdens for smaller entities, the Act fosters growth in the Digital India initiative and provides valuable support to startups. Clear guidelines for organizations. The Act offers clear guidelines for organizations, leading to better compliance and accountability regarding data protection practices. Comparison with global standards. The DPDP Act aligns with global best practices, such as the EU's GDPR, but differs in several key areas. It balances individual rights with the need for national security, public welfare. While it provides a strong framework for data protection, it also reflects India's unique digital ecosystem and national priorities. A new digital era begins. The Digital Personal Data Protection Act of 2023 stands as a landmark legislation in India's digital governance journey. With its citizen-centric approach, the Act empowers individuals by granting them greater control over their personal data, while simultaneously promoting trust in digital platforms and encouraging the growth of the Digital India ecosystem.
I think the DPDP Act can play a remarkable, valuable role in increasing the confidence of the people in the digital public infrastructure. Thanks to this government, we've seen a massive advancement in not just the architecture of the digital public infrastructure, but more significantly, its cyber security aspects. Now, people invariably do not want to trust a digital public infrastructure for the simple reason they are not very sure about how their personal data is going to be dealt with on the said digital public infrastructure or DPI. Once the DPDP Act comes into force, it gives them virtually a solemn promise that please ensure and please be rest assured that your personal data will not be compromised, will not be misused without your consent.
Through innovative features such as gender-inclusive drafting, the use of plain language, and the introduction of a digital nominee, the Act sets new standards for legislative clarity and inclusivity. It also streamlines compliance for businesses, especially startups and small enterprises, by offering exemptions that ease regulatory burdens, ultimately enhancing the country's ease of doing business. The Act provides a robust framework for data fiduciaries, reinforcing accountability and transparency. At the same time, the establishment of the Data Protection Board of India ensures an adjudicatory mechanism for addressing grievances and enforcing obligations. Importantly, the Act introduces necessary exemptions that reflect the practical needs of governance and global engagement. These include government agencies in the interest of national security, public order, and sovereignty, courts and tribunals involved in legal proceedings, startups and small businesses as notified, processing for research, archiving, or statistical purposes, data processing under foreign contracts, especially for non-residents. While such exemptions are integral to the operational flexibility and innovation, they also spark debate about potential overreach and the need for robust oversight to prevent abuse.
21वीं सदी में हमारी बेसिक नीड्स पूरी तरह बदल रही है। कल तक जिसका कोई मूल्य नहीं था, कोई ध्यान नहीं था, वो आने वाले में बहुत अमूल्य बन चुका है। जैसे डेटा, पूरी दुनिया में चर्चा है डेटा का सामर्थ्य क्या होता है। हमने डेटा प्रोटेक्शन बिल ला करके पूरी भावी पीढ़ी को सुरक्षित कर दिया है। पूरी भावी को एक नया शस्त्र हमने उसके हाथ में दिया है, जिसके आधार पर वो अपने भविष्य को बनाने के लिए इसका सही इस्तेमाल भी करेंगे। और डिजिटल पर्सनल डाटा प्रोटेक्शन एक्ट ये हमारी 21वीं सदी की पीढ़ी को और दुनिया के लोगों को भी भारत के इस एक्ट के प्रति रुचि बनी हुई है। दुनिया के देश उसका अध्ययन करते हैं, अपने अपना नई नई व्यवस्था अनुकूल करने के लिए प्रयास कर रहे हैं।
In conclusion, the Digital Personal Data Protection Act represents a crucial step forward in creating a comprehensive, forward-looking data protection regime. It seeks to strike a delicate balance between individual privacy, business innovation, and state interests, an evolving endeavor in the world's largest democracy.